Hello, and welcome to the second webinar in our Investigations and Corporate Crime series. In the first webinar, my London colleague Ben Pilbrow discussed current issues and thinking around private prosecutions north and south of the border. For those who are interested and may have missed that webinar, it is still available to view online. Today, we will explore the issues that arise when a regulatory inspector comes knocking on the door. How a business prepares for or reacts to intervention by a regulator can be significant in determining how such an investigation is ultimately resolved. The importance of advanced planning and the steps to be taken to assist an investigation can never be underestimated. And it may even be more than just a knock on the door. Dawn raids can present significant challenges. The subject of dawn raids, however, will be discussed in more detail later in this webinar series. By way of brief introduction, my name is Kevin Clancy and I'm an associate within the Commercial Disputes and Regulation team. I've been with Shepherd and Wedderburn since 2006, qualified in 2008 and obtained civil rights of audience as a solicitor advocate earlier this year. I have experience advising public and private sector clients, have appeared in both the civil and criminal courts, and have liaised with fiscals around criminal charges in a range of disputes, such as breaches of health and safety legislation, licensing issues, and other regulatory offences. Simply to aid the sound quality for the webinar, please be aware that you've all been placed on mute. It simply helps in minimising background noise. If you do have any questions during the presentation, there is a chat function and I will do my best to answer any questions, time permitting. The webinar should last around 25 to 30 minutes. In terms of the aim for this webinar, I hope you will come away with a better understanding of the types of things that can go well or can go badly wrong, depending on how a business reacts to an incident prompting regulatory intervention. As a Scottish qualified lawyer, some of the terminology I will use this afternoon will likely slip into Scots law. However, the general principles ought to be applicable north and south of the border. To put some context to the webinar, what do I mean by regulatory inspector? Interventions by a regulator can occur in a number of industries and sectors. Unfortunately, time this afternoon does not allow a detailed analysis of each possible regulator. But, for example, in the context of corporate crime, the Health and Safety Executive will feature prominently. As the body responsible for the encouragement, regulation and enforcement of workplace health, safety and welfare, the HSE has a wide remit covering industry sectors such as oil and gas, construction, health services and so on. HSE may ultimately report a matter to Crown Office, and which may then lead to a prosecution. There are two relatively new players on the scene. The Financial Conduct Authority, having succeeded the FSA, is the financial regulatory body in the UK regulating financial firms. It aims to maintain the integrity of UK financial markets with the power to investigate organisations and individuals. The Competition and Markets Authority, having assumed many of the functions of the Competition Commission and the OFT, takes more of an interest in potential criminal cartel offences and will investigate potentially anti-competitive agreements in order to strengthen business competition. So the impact of a regulatory inspector in the corporate world is potentially very wide. But the focus is not just on business. There is an increased focus by regulators generally on the role of individual directors and staff. Increased regulatory focus goes hand in hand with a general emphasis and perception of corporate misfeasance. In recent years, that has come into sharper focus in relation to perceived failings in the oversight of financial institutions. There are two themes or potential areas of concern that we have also seen emerging in recent months. In the world of health and safety, the first relates to an increasing nervousness on the part of insolvency practitioners who, having been appointed to an insolvent company, then found out that an accident has subsequently occurred on the premises. That incident might come to the attention of a HSE inspector, and this is a potential issue arising after the date of appointment, effectively on their watch, when the company has been allowed to continue to trade. The second relates to an announcement earlier this year by the Head of Investigations of the FCA, whereby it was explained that there would be focus on financial crimes, including bribery, and which would include an assessment of preventive controls the company has in place. But as with any investigation, whilst it's impossible to predict what might next appear on a regulator's radar, or where valuable resources might likely be deployed, being prepared is just as important as reacting properly. And that takes me on to my next slide. One of the difficulties that organisations have in thinking through how they will respond to an investigation is the seemingly chaotic and unpredictable way in which situations can develop. Whilst that is true, this does not mean that an investigation cannot be planned for, anticipated, and in some cases, predicted. Equally, there will be occasions where organisations need to think the unthinkable, that someone has been lying to them, or a senior board member might be held liable for a criminal failure, or an employee may be engaging in corrupt practices. Examples of regulatory investigations that ultimately lead to criminal trials generally occur when no proper management processes have been put in place, training manuals are out of date, or there was insufficient awareness of the potential for an accident or offence to occur. Organisations that have no system for investigating near misses are also not likely to be viewed particularly positively by an inspector. Whilst accidents or offences can sometimes be entirely unpredictable, it is also remarkable how minor omissions and errors, sometimes evolving over years, ultimately lead to regulatory intervention. And this is one reason why regulators and inspectors consistently stress the importance of embedding a compliance culture within organisations. Picking up the small issues can avoid the bigger problems later on. The key to success lies in the planning. Organisations could and should be able to identify key risk areas and prepare an issues or risks audit. This is in terms of both known internal risks, but also the identification of future emerging risks. The involvement of senior staff in the process is significant. For regulators such as HSE, tone at the top is paramount. And the same could also be said of the SFO's view in respect of bribery and corruption. And a focus on individuals should also mean that compliance messages truly hit home. The importance of proper planning, preparation and review also comes into sharper focus at the time of regulatory intervention, because that prior work may be instrumental in avoiding a subsequent prosecution. For example, most statutory offences normally include what might be described as some sort of saving provision. Health and safety legislation makes reference to so far as reasonably practicable. The Corporate Bribery Act offence provides for an adequate procedures defence, whilst liquor licensing permits a due diligence defence. Taking liquor licensing as an example, I was previously instructed in relation to a failed test purchase of alcohol at a shop. At the risk of stating the obvious, this is when police conduct an operation concerning the sale of alcohol to children and young persons. It is a criminal offence to fail such a test in terms of the Licensing Scotland Act. Strict liability was imposed upon the manager, my client, in addition to the individual who sold alcohol to a minor. The matter was investigated internally and externally, referred to Crown Office, and a prosecution commenced. However, because the client had kept robust training records, had put in place detailed procedures, and had cooperated fully with the investigation, the prosecutor ultimately agreed to drop the case as the evidence disclosed that the statutory defence had been made out. This also highlighted the importance of maintaining a written record of training and a proper audit trail. The absence of written records would almost certainly have meant a different outcome for the manager. Looking at matters another way, the worst situation is having to deal with these issues for the first time when something goes wrong and an investigation is unfolding. In most industries and sectors, there will likely be an obligation to report an accident or illegal act. For some offences, such as those under the Bribery Act, a decision may need to be taken on whether to self-report. The key is not to appear obstructive or overly defensive. The inspector will expect cooperation, and there are more advantages than disadvantages in facilitating an investigation with the regulator. I'm also aware of clients undertaking their own internal investigation in parallel. A common issue that we find cropping up, and which tends to cause inevitable stress, is the possibility that employees will be interviewed as witnesses, and may even be interviewed under caution. This is a process that needs to be managed correctly. Seeking the early assistance of the in-house legal team or external counsel will be important not just to ensure that the employee properly understands the procedure, but is also properly represented if required. Linked to this issue is the wider question of legal representation. It is quite possible the investigation might begin to narrow its focus onto a particular individual. The investigative process needs to be closely managed, and that is especially so where the interests of an individual begin to diverge from, or may even begin to conflict with, the interests of the organisation, and separate legal representation may well be required. When an inspector does come along, it is important that there are clear processes and procedures to ensure that the matter is escalated internally to the correct level. An organisation will not want individuals further down the chain of command giving unguarded, mistaken, or plainly wrong, even if well-intended answers to an inspector. The different regulators will have different powers of inspection, and the slide presents a number of the most common powers. Some may look familiar. But as every regime is different, that again serves to highlight why prior planning is important. It is crucial that the internal team has a solid understanding of what the investigator's powers and functions actually are. This is to ensure the inspector is not extending beyond his or her entitlements. Equally, it ensures that a senior manager does not inadvertently obstruct an inspector in the performance of his or her duties. It is important to cooperate with an investigation, provided that investigation is being conducted within the parameters of the relevant legislation and guidance. You might want to ask yourself this question: if pressed, would your senior managers know what powers and entitlements are open to your regulator during the course of an investigation? As for reaction, one need only look at news that broke last week in connection with the handling of allegations around vehicle emissions testing and the crisis that has engulfed Volkswagen in America. Whilst details of the offence remain sketchy, the US Environmental Protection Agency is making noises about financial penalties, whilst a criminal probe cannot be ruled out. The reaction of Volkswagen comes into sharper focus when one considers that back in 2014, and at a time when regulators raised concerns about the emissions levels, those concerns were seemingly dismissed by Volkswagen as mere technical issues. That might invite a troubling conclusion that either there was a failure to properly engage with the EPA's investigation, or executives and managers may have misled officials. This is a fast-moving crisis, and these issues may become clearer in the months ahead. An investigation by an inspector, or an internal investigation in parallel, is required in order to uncover the factual context in which the accident or offence occurred. An important function of most investigations is to identify poor practice and systems, in particular the how or why the incident was able to occur. If poor practice is identified during the course of an investigation, then it is equally important to ensure that questionable practice is not allowed to continue. That is not an admission of guilt. On any view, it is worse to try and deal with the consequences of continuing to operate a poor system, rather than explain to an inspector why the system was changed. By taking timely interim action, whilst the organisation might not be able to avoid a prosecution for the incident that has already occurred, proactive cooperation and remedial action may assist when it comes to issues around mitigation. Indeed, I've been involved in 2 cases that proceeded to a criminal hearing where the client's proactive response to an incident was set out in both the Crown narrative and the plea in mitigation. If an organisation is also undertaking its own internal investigation with a view to sharing any conclusions, then a key issue is to ensure that the investigation stands up to scrutiny, that it is viewed as robust and independent. If it is, then third parties, such as regulators, are much more likely to accept those conclusions. Care, however, must be taken to ensure that personnel said to be linked to the very conduct prompting the investigation take no role in directing the investigative process, whether internally or with the regulator. Who leads the internal investigation in most cases will depend on the situation. Often that could be the in-house legal team, but equally it is possible that the in-house team lacks the resources and time to carry out an investigation in what is likely to be a fast-moving environment. Looking to external solicitors and other professionals, such as forensic accountants, is likely to provide the best solution in a difficult and challenging situation. Externals provide independence, they will have the resources to carry out document reviews, and, equally as important, external solicitors optimise the opportunities for retaining privilege in the investigation. The question of privilege and how the courts interpret it could be a webinar in itself. And you will recall from an earlier slide that the inspector's powers may include the inspection and copying of documents. One of the questions we are often asked, given the difficulties in controlling the production of documents, is how can documents be managed and protected within obligations around disclosure. The key difference is identifying documents that may be viewed as commercially sensitive or confidential, but which would likely require to be disclosed, and those documents that are protected by legal professional privilege. Robust advice around this issue is important if the regulatory body is seeking the disclosure of information. It may be possible to request restrictions on the use of that information. It may be possible to obtain an order for that material to be disclosed on a more limited basis. Every situation is different and requires careful consideration. It is extremely challenging and difficult to handle investigations well, to minimise reputational damage to the organisation, and to ensure that individual reputations are maintained. That is especially so if events are moving rapidly and key individuals within the organisation do not have access to all the relevant and important information. I've already alluded to the Volkswagen investigation. The making of public statements after the inspector has shown up is also very challenging. It is a minefield in practice. Often, key managers or board members can find themselves making public statements in extremely stressful environments when they do not understand all the facts, and which are subsequently shown to be inaccurate or misleading. Incorrect assumptions can cause damage to both the business and to the individual. And issues of public statements and social media will be covered later in this webinar series. Senior staff can be guilty of mishandling press attention, creating additional problems. So, for example, the criticisms made against Tony Hayward of BP for his initial comments following the Deepwater Horizon crisis off the coast of America were personally damaging to him to BP as a company and distracted from the message that BP was trying to promote at the time. If the investigation or the response to an investigation has been mishandled, then another consequence might be to remove legal privilege from key areas of the investigation, and the knock-on effect might be to expose the business to increased civil liabilities. The final bullet point on that slide is a significant failing. A recent example is highlighted in an FCA press release in March of this year concerning the Bank of Beirut. Supervisory visits had been made to the bank in 2011, with the regulator concluding that too little consideration was being given to the risks of financial crime, in particular customer due diligence. These were significant cultural failings. The bank was required to address these issues. However, it is said the bank repeatedly provided misleading information to the regulator, indicating that the bank had completed remedial actions when it had not. That is a problem. Dealings with any regulator need to be honest, accurate and complete. The bank was fined £2.1 million. I also mentioned previously the impact an investigation can have on individuals. In this case, the former compliance officer and the internal auditor were also implicated. And that leads on to potential penalties, both civil and criminal. On the civil side of things, organisations can suffer financial and reputational damage. There may also be litigation in the civil courts. These are also relevant considerations on the criminal side of things. There are additional threats should the matter be referred to Crown Office, leading to a successful prosecution, with penalties such as fines, imprisonment, and, where the prosecutor considers it appropriate, an order for disqualification from acting as a director. If nothing else, this further illustrates the importance of directors taking responsibility for their own liability and risk. This means being proactive. If there are questions, then answers should be sought. It also comes back to the issue of culture. Senior officers should be assertive and take responsibility for compliance. When a regulatory inspector comes calling, ideally the preparation will have been put in place well in advance. Effective management and controls are essential. However, an organisation should not be unduly fearful of engaging with the inspector. You know your business better than the inspector does. You know what documentary evidence exists and might satisfy questions such as due diligence and adequate procedures. Record keeping is crucial. That early engagement with the inspector may be enough for a satisfactory conclusion to the incident and so avoid the threat of prosecution. Investigations can be challenging, they can be time-consuming, and they can be stressful. But with appropriate planning, strong leadership, a sensible strategy, and an effective team in place, it is still possible to come out of an investigation with reputations remaining undamaged and prosecutions or court actions avoided. That brings this webinar to a conclusion. Regulatory intervention, or having inspectors on site, is not something businesses proactively seek out. However, I hope you found the topic to be an interesting one, and that might have provoked one or two thoughts around the challenges arising from an investigation. The third webinar in our series is scheduled for 29 October, and we'd be delighted if you would join us, and the webinar will be dealing with the subject of dawn raids. Having a look at the chat box, there doesn't seem to be any questions arising, so thank you for attending this afternoon.